recent years we've actually seen a large growth in our defamation practice, due in large part to the rise in online defamation. Increasing reliance on the internet by both businesses and consumers means that companies are now more invested in a presence online. So naturally they're much more conscious and vigilant of online publications and comments where they're defamed in some way. Companies will generally react pretty swiftly to comments which overstep the mark on social media forums. There's generally two ways that a company can address that type of behaviour. The first is to demand action from the publishing site or search engine such as Facebook or Google. If they're alerted to clear defamatory content, they will generally take action and remove the comment, or in the case of Google, remove the link to the offending website. There's a raft of recent cases of Australians bringing claims against those types of companies for failure to remove defamatory publications. In relation to the US-based Google Incorporated, which operates the global search engine, their liability to remove defamatory content in Australia has been the question of a lot of recent debate and continues to be litigated in the Australian courts, and the case law is in a state of flux to some extent. So taking on the big multinational companies on those issues is still somewhat uncertain and an unattractive proposition. Accordingly, more often than not, the complaints are directed at the source of the publication. The Defamation Act in Queensland sets out a regime for providing notice to an offender, which ordinarily involves a letter requesting the removal of the content and perhaps some other relief such as an apology. If that's simply ignored, 9 times out of 10 court proceedings will follow soon after. Accordingly, it's important to know what you can and can't say online.